Good day to you, Alan. My name is Queenie Tang. Let's look into the first issue that you are curious about. The establishment of LRA 2002 actually aims to ensure the land ownership in England and Wales takes the form of title by registration rather than registration of title. This aid also provides clarity and security for registered owners by recording all proprietary interests. In this regard, the system of land registration relies on three principles. The first one is the mirror principle. All the important and significant details that a purchaser must know before buying the land or property will be reflected accurately under the register and allows the public to view. The second one is the curtain principle. The purchaser does not need to look beyond the register to discover any hidden equitable interests because he or she will not be bound by them. The third one will be the insurance principle. The accuracy of the register is guaranteed. The state will compensate the landowner for any loss which arises out of reliance on any errors on the register under Article 8 of the LRA 2002. The inaccurate register will be altered as well under Article 4 of LRA 2002. Under Section 29, subsection 1, once the interest of the purchaser is properly registered, then it will take priority over any unprotected pre-existing interest on the register at the time of registration. Normally, after a disposition of land is registered, the unregistered interest in the land will no longer affect the land. However, regarding Section 29, subsection 2, there are exceptions, such as interests that are registered, plus according to Schedule 3, which are categorized under interests that override, and they may override a registered owner's title. What is overriding interest, or we call it as ITO? Under the Section 70, subsection 1, subsection G, LRA 1925, it refers to interests that are not protected on the land register, but will nevertheless bind the purchaser of the registered land, which is known as a crack in the mirror. It has now been replaced by LRA 2002. Under the LRA 2002, it was called interest that override. Regarding the Schedule 3, it means unregistered interests which override a registered disposition. Examples of interests that override under the LRA 2002, which may bind subsequent owners of registered land even if they are not registered on the title, include short leases. Schedule 3, paragraph 1. A legal lease for a term which does not exceed 7 years is typically an interest that overrides even if unregistered. If Tina's lease meets this criterion, it could potentially override your title. The second one is the actual occupation. Under the Schedule 3, paragraph 2, an interest belonging to an individual who has an actual occupation of property or land at the time of the disposition, despite non-registration. And the last one is the legal easements or profits under the Schedule 3, paragraph 3. For example, the right-of-way. Moving on to the next issue, because you are a registered proprietor, that means your title and interest for this freehold property will be legally protected, but it is not absolute. And we will have to consider whether Tina has a freehold interest, legal or equitable interest, which may override your title. For legal lease, under Section 52, subsection 1 and 54, subsection 2 of the Law of Property Acts 1925, a deed is compulsorily required if a term of leases over 3 years, or else it is invalid, or it will be assisted as an equitable lease. In Tina's case, it was not clearly stated whether there was a deed created. If there is a deed, then she would have legal interest. In this regard, Schedule 3, paragraph 1 of LRA 2002 that stated a legal lease for a term which does not exceed 7 years will be applied, and it is typically an interest that overrides. Also, under Section 27, subsection 2, subsection B1, LRA 2002, it was stated that only if a legal lease is granted for a term of more than 7 years, then it must be registered at the land registry as a title. That means short leases require no registration. In Tina's case, she claimed to have a lease agreement with Charles, which allows her to stay on the property for another 5 years. Regarding this, she meets the requirements of short lease under Schedule 3, paragraph 1, which is under 7 years. So there is a high possibility for her to override your registered title even without being registered. Let's look at another possibility. What if she has an equitable interest? According to Section 1, Subsection 3 of LPA 1925, all other estates, interests, and charges in or over land will take effect as equitable interest. Concurrently, Schedule 3, Paragraph 2 of the LRA 2002 will be applied to her case. We will have to determine whether she has an actual occupation of your property at the time of disposition, despite non-registration. What is the actual occupation? It actually refers to a physical presence that is appropriate to the kind of land in question, such as living on residential land. It also means an apparent occupation of the property or land. Generally, the lease will not be binding unless it has been entered as a notice under Section 28 and 29 of the LRA 2002. For Tina's case, we may refer to several cases to make determination. First, it is a case called Hodgson versus Marks 1971. In this case, the court held that even though Mrs. Hodgson shared the occupation of the property with the registered proprietor, she was in actual occupation, and she had been there before the transfer, so she would have an overriding interest which bonds the subsequent purchaser. Moreover, in a case called link landing, the court held that Miss Bustard was in actual occupation of the property because of her persistent intention to return home and a sufficient degree of continuity and permanence of occupation. So, she was entitled to priority protection of an overriding interest. In another case called William and Glyn's Bank, the House of Lords held that each wife who physically lived in their matrimonial home was in actual occupation. Their rights as occupiers and equitable interests in actual occupation were recognized as overriding interest and being protected. Besides, Lord Denning also refuted the statement made by Stan J. and Templeman J. by stressing that two people can be in actual occupation and the wife also clearly has rights as long as she does live on the property. Temporary absence will not affect the actual occupation of the property. This is supported by a case called Chokar versus Chokar 1984. The Court of Appeal held that Mrs. Chokar was in actual occupation because her furniture was still at the property. So her temporarily leaving home to stay in a hospital will not cause the loss of her actual occupation and also her overriding interest. Only if Tina left the property with no intention of returning and occupying the property just like in Thompson versus Foy 2009 case, then her actual occupation of the property will be ceased. Lewis L.J. also mentioned that an interest belonging to an individual in an actual occupation both at the disposition date and at the time of registration. Only if Tina had never lived on the property for a long time. For example, in Stockholm versus Finance case, the court held that the princess' prolonged absence from the house for over a year could not constitute actual occupation, so no overriding interest. In Tina's case, she had been living on the property for the past 2 years. It seemed that the requirement where there was a sufficient degree of continuity and permanence of occupation, as stated in the case of link landing, was fulfilled. Additionally, she also physically lives on the property before and at the time of your purchase, which is similar to the facts in the Hodgson and William cases. Throughout her actual occupation, she might have temporary absence, but it will not affect her overriding interest as stated in Chukar case. So, she satisfies the elements of actual occupation under the equitable interest. In conclusion, even if the lease is unregistered, Tina's interest and the alleged lease will still override your registered title if her occupation is so obvious upon reasonable inspection. No matter she owns legal interest or equitable interest, as she meets the requirements of short leases, which are less than 7 years under Schedule 3, Paragraph 1, and fulfill the actual occupation standards under Schedule 3, Paragraph 2. Let's look at the third issue. First of all, what is the option to purchase OTP? In an early Montana case, Ide versus Leeser 1890, it refers to an agreement in writing to give a person the option to purchase lands within a given time at a named price, and it is not an agreement to sell, but simply a contract. Within this specified time period, the sellers cannot provide other parties with offers or sell the property to them. In David's case, he claims an option to purchase the property, which is a form of equitable interest. Since you found no record of this option at the land registry, it suggests that this option was not registered. Under Section 29, subsection 1 of the LRA 2002, once the interest of the purchaser is properly registered, then it will take priority. Under Section 32 of the LRA 2002, the entry of notice in the land register will protect a third-party interest in land and ensure it binds future purchasers of the land. Under Section 4, subsection 5 of the Land Charges Act 1972, the unregistered Class C IV land charges are void against a purchaser of a legal estate in the land who gives money or money's worth. In this regard, we may refer to Midland Bank Trust case. The court held that the son's unregistered option to purchase was unenforceable against the wife who was the subsequent purchaser, and her notice of option is irrelevant. All land charges, even if unregistered, will be valid against a non-purchaser only if the land is transferred by gift. So an unregistered land charge will not bind a subsequent purchaser even if he or she knew about the charge prior to the purchase. Another similar case is Welford versus Mouse, 1992. The court held that the lockout agreement was void for uncertainty due to lack of a specified end date, and this case highlighted the importance of precise terms and compliance with formalities in agreements. In David's case, it was also not clearly mentioned that David and Charles had signed the OTP agreements with specified terms, which include specific end dates and price, like in Welford case. And the property was not even gifted by Charles to David as well. Only David unilaterally mentioned he had an option to purchase the property. Also, an option to purchase typically needs to be protected by registration as an agreed notice to bind subsequent purchasers. Failing this, it may not bind you according to Midland case, unless it qualifies as an overriding interest. Options to purchase are generally not overriding interests under Schedule 3, so they will not bind a subsequent purchaser unless they registered. In order to establish an overriding interest, David must prove he had an interest in land at the time of disposition and he was in actual occupation despite non-registration as stated in Section 70, subsection 1, subsection G, and Schedule 3, paragraph 2. This is supported by a case called AB National Building Society, where the House of Lords highlighted that the right must exist and the actual occupation should have some degree of permanence or continuity, and it should have occurred before the transfer of the legal estate. In Clean case, the court held that the regular use may also amount to actual occupation, and he also has intention to return to the property, so his right as an overriding interest was protected. In David's case, it is very unlikely that he had an overriding interest due to the fact that he only entered into the property with Charles 3 years ago. The facts suggest no such actual occupation at the property, no regular use, and no intention to occupy or return to the property like in Clean case, and did not fulfill the standard of permanence or continuity in terms of occupation before the property transfer like in AB National Building Society case. So in conclusion, your position as the new owner will not be affected, and you are able to take the property free of David's option, as David did not register his option to purchase and he did not have an overriding interest which could be bound on you. And this is the reference list. That is all from me. Thank you for listening.